an A buyer's rider? Well, it's going to differ from attorney to another attorney. However, I'm going to explain what I put in my riders. Now, the contract you sign may not have all these provisions. Unfortunately, not every attorney that is on the seller side is going to grant me all these provisions. I do have a good relationship with most of the attorneys, whether downstate, upstate, and since I do so many closings, a lot of times from my prior dealings, I'll get a lot of this stuff granted. So if you don't have this in your particular contract, or your attorney didn't provide you with this, you'll know why there might be some deviation from that. You may also want to come back to your attorney and ask for a specific provision. I also, before I begin, get criticized a lot for restating a lot of the contract, but I like to write in a non-legal lease type of manner so my clients can understand it and feel comfortable when they're signing my contract. So my rider first says that my rider controls over the contract and the seller's rider. Hence the reason why I do a lot of the repeating, but I do it so in a more normal speaking manner or normal writing for comprehension purposes. One, I want to put that there's not going to be any violations that are going to be part of the property. The contract may differ from that, so you want to, if it does differ and you don't have that in your rider, make sure you see where the point is where you're getting the property with no violations. I'll put that I want the property vacant and broom clean at the time of closing. Sometimes this is not the deal, so if that's not the case, don't worry about it. I'm going to put that the appliances and major systems, including AC, electrical, plumbing, heating, are all in working order, and that there's no broken windows. Not saying your home has broken windows, but sometimes I've had fights over a window that was cracked, and the seller maintained that that's the way it was at inspection. Notices. Nowadays, we have notices that everyone sends via email, but the contract typically doesn't allow that. So I want to include that if I do send a notice via email, it's going to be sufficient for legal purposes later on. The standard contract of sale does not allow for an FHA loan or a VA loan or some other type of variation loans like Sony Mae, for instance. So if you're getting one of those type of loans, I'm going to put that in there that you're allowed to get that. The regular contract, again, I said, does not allow that. So theoretically, if you get denied one of those loans, then you're in default and you will lose your down payment because you were never supposed to apply for one of those in the beginning. Now, going to mortgages. Paragraph 8 of the standard form contract in New York gives you the amount of days that you have to get a loan commitment and the type of loan, like we spoke about before. In addition, the amount of the loan. Make sure the amount of the loan that you're applying for matches up with the contract. If it is more than that amount, the same rule applies. If you get denied for a higher amount, you're in default of the contract. If you get denied for the loan amount that you're applying for, and there was through no fault of your own, you should be getting your money returned. Now, you're always allowed to apply for less, but again, your denial can't be based on more or that lesser amount. It has to be for the amount in paragraph 8. And again, the type of loan has to be correct. I typically like to put in my contract that there is no automatic waiver of the loan contingency for failure to notify the seller that we do not have a commitment. Now, if your contract says you have 30 days to get a loan commitment and your attorney is not reminded or does not calendar the 30-day period and ask for an extension, technically your loan will eventually become a no loan purchase and it becomes a cash buy. Very simple to avoid that, and how a lot of people lose their down payment is by just mentioning to your attorney, my extension is ending up on this day, or my commitment is supposed to be provided by this day, please ask for an extension. And when you get that extension, like I just said before, ask for another extension when you're getting close to that date. Why may you not be able to get a commitment, which is different than a pre-approval? A commitment is the bank saying, give me these conditions and I'm giving you this loan. It could be a number of reasons. Could be something like verification of employment, things that are out of your control. If you're diligent, it's not your fault, but you still want to ask for an extension so you can prove that you are being diligent, and at least you have the opportunity, if the seller comes back and says, I'm not giving you an extension, you can say, well, if you're not giving me an extension, I would like my money back and I'm canceling. In addition, The standard form contract, and this is gonna blow your mind, actually states that once you get a commitment, you're bound to close even if the lender does not fund. Some contracts won't have that because some attorneys have removed it over time, but typically the standard form contract says if you have a commitment, you're bound to close no matter what. So if you go to a lender that doesn't really know what they're doing or didn't pre-approve you right, sends you a commitment which has 1,000 conditions, and is treated as a mortgage commitment, we're gonna have a difficult time. However, what I put in my rider is once you obtain a commitment, if the lender doesn't fund and it's through no fault of your own, you'll get your money back. So that's one thing I really try to fight for. I can't tell how many times we'll have a loan commitment and it may be a lender that I'm not normally working with, and unfortunately, the deal does not go through. We want to make sure the property appraises. Now, I understand sometimes you're in a seller's market and you may agree to waive the appraisal. Well, I try to not have you waive an appraisal. I try to get an amount where you have a range. So, you know, if your appraisal comes in completely off the wall, $100,000 below value, you're not gonna have any real issues. You know, try to negotiate before or during your offer, you know, a 10 to 15 to 20,000, something reasonable that you say, you know what, on top of my closing costs, I can afford to come up with this. Again, that's in a seller's market. But normally, what I have in here is that the property doesn't appraise and the seller and the buyer can't come to terms on lowering the amount, then the purchaser will get back their money in full. You want to make sure that's in there. Some attorneys have a stance if you're going to go for, let's say, a conventional loan and you're putting, you know, 20, 30% down, that an appraisal doesn't make a difference provided you're approved for the loan. And depending on your buying power, you might be approved for a loan even though it did not appraise for value. So make sure that that's in there. I want to make sure who's paying the transfer tax. In New York, depending the area you're in, it could be really expensive. So I want to make sure that the purchaser is not paying the transfer tax unless it is a foreclosure, which is customary, or new construction, which is also customary. But even in a new construction, I've had clients negotiate, I'll pay half the transfer tax, or I won't pay any transfer tax. It also depends, you know, what kind of the economy we're in, what kind of market, seller, buyer, etc. And lastly, some attorneys sneak in that the default is 10% of the purchase price, no matter what the down payment is. This more applies to FHA loans or 5% conventional loans when you're putting down 5%. I make sure that the contract reads the default provision is the down payment. And again, as long as you follow everything we talk about when we go over the contract, there should be no reason why you should ever lose your down payment. And as you can see, my rider really goes above and beyond most other riders. Compare it to your friends and what they signed, and you'll see that there's a lot of protections that we fought and were able to achieve. Hope you're enjoying the videos that you've watched today. They're not meant to be a substitution for speaking with your legal professional, but just an educational tool. Thank you.